Hi, my name is Jacob Blizzard. I'm a board-certified criminal law and criminal appeal specialist attorney. Today I wanted to talk to you about 3 common myths associated with pursuing an appeal in your case. 1, appeals never work. It's a common myth out there that why bother with an appeal, they're just going to affirm your conviction, so why pursue it? Well, appeals are a valuable right that we hold when you're accused of a crime, you're convicted of a crime. There's an appellate court that looks at your case from a dispassionate point of view. They're looking at it, they're not there on the ground looking at the witnesses and sympathizing with a potential victim or something like that. They're looking at the facts on paper and what was proven, what errors may have happened in your trial, and so appeals are winnable. Now, appellate courts do tend to affirm convictions. That's why you really need a very skilled appellate attorney to pursue an appeal for you. Somebody who can recognize the appropriate grounds. Because there are certain recognized grounds that you want to pursue in an appeal, and there are grounds that are just never going to get you anywhere. And so doing it on your own is not advisable. You certainly need to get a quality appellate attorney to do it for you. Number 2, I can introduce new evidence in my appeal. A lot of people think that an appeal is like another trial, where you can introduce new evidence and the court will look at it, and you may say, well, there was a video or a statement or a witness or something that if only they would have been presented at my trial, I wouldn't have been convicted. And so I'm going to present that to the appellate court. Well, you only have a very limited right to do that because the appellate court looks at the case from the perspective of what's in the record. So if you think about what's in the record, there's the clerk's record and there's the reporter's record. The clerk's record is all of the paper filings that were done in your case. Motions, responses, orders, objections that were made on the record, things like that. Then you have the reporter's record, which is the transcript of your trial. So it goes through and logs all of the witnesses and what every person in the trial said, objections that were made, the rulings of the court, and those are the things that the appellate court looks at. And appellate attorneys file a brief based upon the things that are contained within the appellate record. And so there's not an opportunity to introduce new evidence in the appeal process. The only way you can really introduce new evidence in the appeal process is if you file a motion for new trial. Motions for new trial have to be filed within 30 days of your conviction. And you have to attach that evidence in that motion for new trial and then have a hearing on it. And then that becomes a part of the record. And so that record then goes up to the Court of Appeals and it's reviewed as a part of the whole record that you had from your trial. That's really the only limited way on a direct appeal that you can have new evidence considered. However, you can still pursue a post-conviction writ of habeas corpus where you could present new evidence, but that comes after an appeal. Number 3. I'm entitled to a court-appointed attorney through the entire process. Well, that's sort of true, sort of not true. You are entitled to a court-appointed attorney if you qualify, if you're declared indigent, which a lot of people who are incarcerated then become indigent even if you were out on bond prior to your trial. If you were on bond and then you were convicted, then you're now in custody. You don't have the ability to earn income, and so you could be qualified to receive a court-appointed attorney. However, a court-appointed attorney on appeal is limited to only that first court of appeals. So there are 14 districts in Texas and 14 courts of appeals. And then there's the Court of Criminal Appeals, which would be the court of last resort in Texas above the Court of Appeals of the various districts. So you're entitled to a court-appointed attorney only for your appeal from the trial court to that district court of appeals. And your attorney would review the records and they would file a brief on your behalf. But if your conviction is affirmed on appeal, then there are further rights you still have to petition the Court of Criminal Appeals to hear your case, except you're not entitled to a court-appointed attorney to do that. You, on your own, have to pursue a petition for discretionary review with the Court of Criminal Appeals. If the Court of Criminal Appeals were to grant your petition, then they would again allow you to have a court-appointed attorney to submit a brief. And then if you were denied at the Court of Criminal Appeals, of course, you can file a petition for discretionary review at the Supreme Court. It's called a writ of certiorari. And you're not entitled to a lawyer to do that either. However, at each of these stages, you're entitled to a lawyer if you get to that part where there's a brief that needs to be prepared. But for the most part, you are going to be limited to the court-appointed attorney for only that first level of appeal. And I would advise, even if you don't have a court-appointed attorney, to get an attorney to help you with the petition for discretionary review, because you're not entitled to a court-appointed attorney. And the petition for discretionary review is very important. It's the thing that is going to determine whether or not the Court of Criminal Appeals is going to look at it. And there's a number of very specific factors that you need to rely upon to get the Court of Criminal Appeals to review your case. They're not just going to review your case simply because the case was wrong or because an injustice occurred. It has to relate more to overall jurisprudence in the state of Texas. And so a quality appellate attorney is going to know how to do that for your case to make it something that is likely to be granted. All right, so we've discussed the three most common myths in appeals. A remedy to much of this is to hire an attorney to help you through an appeal. An appeal is not something that I would advise you go on your own through. If you can get a court-appointed attorney and that's the way you want to go that way. If you can't get a court-appointed attorney, or if you want to hire a quality attorney, look for an attorney that's board certified in criminal appellate law. Thanks for watching, guys. We'll see you next time. Thanks.